Hi everyone, my name is Nina Holatova and I am a lawyer and program coordinator at the Community Legal Education Association, or CLEA, located in Winnipeg, Manitoba. CLEA is a not-for-profit organization and we offer legal education, information, and other resources across the province. This presentation is going to be part 1 of 3 in a series of presentations about family law in Manitoba. Today we're going to be talking about your options upon separation, what you can expect when meeting with a lawyer, and going to court. The contents of today's presentation are for general information only and do not constitute legal advice. If you do require legal information about your specific situation and you do not have a lawyer, you can contact our law phone-in program for free legal information. The first thing that we're going to talk about today is the difference between being married versus being in a common law relationship, and then also sort of the difference between separation and divorce. In the past, marriage was seen as the union of one man and one woman, and obviously things have changed because we now have common law unions, which are also recognized under the law, and as well, same-sex couples, or really couples of any gender, can get married or enter into common law unions, and they will be treated equally under the law. The main thing that you need to know about separation versus divorce is that if you are in a common law union with someone, then you will go through a separation, whereas if you are married, typically you will go through a 1-year period of separation and you will then file for a divorce. So if you're going through a common law separation, it's going to be provincial legislation that applies. And in Manitoba, we have something called the Family Law Act, which governs these issues. On the other hand, if you're going through a divorce, then it's going to be federal legislation that applies. And in this case, it's going to be the Divorce Act. People sometimes ask about annulment, but this is something that really doesn't come up very often. Typically, people just go through the separation and divorce process. You might see an annulment where maybe a marriage wasn't performed properly under the law, or in cases of a sham marriage, maybe where someone got married just for the purposes of immigrating to Canada, and it wasn't a marriage that was entered into in good faith. But again, this is something that's pretty uncommon. Religious annulments are also possible, and this might hold some religious value to people, but ultimately this doesn't have any legal bearing. So if you are looking for ultimately a change of status, then you are going to have to go through the courts to either seek that annulment or more likely a divorce. So what does it mean to be in a common law union? There are 2 ways to enter into a common law union with someone. The first is to register with Vital Statistics, and this is something that comes into effect instantly. So you would file a form, you pay your registration fee, and then as soon as that's processed, you and your partner are considered to be in a common law union. If you are not registered, which is more common, then you have to prove that you have either been living together for 3 years or that you've been living together for 1 year and that there's a child of that relationship. Now, these criteria are very important. With that 3-year benchmark, if you and your partner have been living together for 3 years, this is going to allow you access to all of the remedies that family law in Manitoba can offer. So this means things like child support, parenting arrangements, spousal support or common law partner support, property division, and everything else. So at that 3-year mark, essentially it's the same as being married. However, those property remedies, that property division aspect, doesn't come with the 1-year cohabitation with a child. So if you fall under this category, you would not be able to ask for property division, but you can still ask for all of the other things like support, including child and common law partner support, and you can still deal with parenting arrangements. You should also know that there are different timelines that might apply for Canada Pension Plan or CPP, as well as employment pensions. So CPP is generally shareable after 1 year of cohabitation, and for employment pensions, there are different rules that apply depending on when the partners are separated. So in order to be considered a common law union, you have to be living together with your partner in what's called a conjugal relationship. This is different from living with, say, a roommate or a friend, or maybe a landlord-tenant relationship where both people are living under the same roof. And there are a few different factors that the court would look at when deciding whether two people were living together in a conjugal relationship. Essentially, it means a marriage-like or committed relationship, and I've put some of the factors up on the slide that the court would consider. Now, the court would look at all of these factors, but none of them on their own are necessarily determinative or a requirement. So you'll notice that sexual relationship is listed. However, it's completely possible for two people to be living in a conjugal relationship without that sexual aspect to their relationship. And at the same time, it's completely possible to be living with somebody and to be in a sexual relationship with them, but that may not be enough on its own to constitute a conjugal relationship. So, really, we want to look at all of the factors as a whole. Going through the factors briefly, the court will look at things like, do the parties live together? Is there a sexual relationship? Do they do things for each other? So, do they share tasks like cooking and cleaning and household chores? What about the social aspect of their lives? Do their friends and family and the people around them know that they're a couple? Do they hold themselves out to be a couple to other people? Is there mutual financial support? Do they share finances? Do they have maybe a joint bank account? These things are all going to be important. Now, although that common law status would kick in at different times, either that 3 years or alternatively that 1 year with a child benchmark, that cohabitation date, or that date that really marks the commencement of the relationship in a legal sense, is going to go back in time to when the parties started living together. And all of these factors can be important for determining the start of the relationship. But more commonly, they are used to determine when the separation date was, because couples sometimes can't agree on that separation date, and it can be very important, particularly for property reasons, if that applies. Now, if the couple has been married, they can get divorced. And as I said, divorce is something that's only available to people who have been married, not for common law relationships. And divorce is just a change of status. So if you want to get remarried at some point down the line, this is going to be important because you're going to have to get a certificate of divorce, which you can only obtain through court. However, there are many people out there who are married and who separate and who choose just to never finalize their divorce. This is maybe a little bit more common with older couples who don't have any children, or maybe their children are grown up. Maybe they've been able to deal with all of the other issues like property division if they had any property between them. And some people figure it's not important to me to be able to get remarried in the future. I don't see that for myself, and they simply choose not to finalize things. However, if you do want to get a divorce, you're going to have to show that there has been a marriage breakdown, and this is usually proven by separation for 1 calendar year. So if you've been separated for a year from your spouse, you can go ahead and ask the court to grant you that divorce. However, if there are other issues to deal with, like custody or support or property division, you might have to deal with those first. There are some other grounds for divorce, like cruelty and adultery. However, these are not commonly relied upon through the courts because it is just too costly and it takes too much time to prove them. So, more commonly, people will just wait for that 1 year of separation to go by, and then they can go to the court and ask the court to grant that divorce. That being said, before that 1 year of separation goes by, you can absolutely deal with other issues related to divorce. So you can still deal with issues like property division, custody, support, etc., before that divorce can actually be granted. The next question that someone might have is, what are my options upon separation? Although a separation or divorce is something that no one hopes to go through, it's a situation that's pretty common. And someone in that situation suddenly might realize that they aren't really sure what is available to them, or what the law says, or what steps they can take next. And for a lot of people, this is really their first point of contact with the formal legal system. So let's talk about what some of those options might be. The first option is to do nothing. Maybe there are no issues. Maybe you and your ex-partner are able to agree on everything and figure it out between yourselves, and you can go your separate ways and everyone's happy, which is great. And this is common maybe for younger couples who haven't really intertwined their property, who don't have children together. Maybe they're just renting and it's not really that complicated for them to separate, go their separate ways, and just figure things out between the two of them. However, if there is something that the parties can't agree upon, then one of them may need to take further steps, including legal action. In order to actually get a divorce, you have to eventually go through the court, but that doesn't mean that you can't deal with other things outside of the court. And I'm sure that every family lawyer in Manitoba will tell you that it is much better to negotiate and settle things outside of court as much as possible and as much as is reasonable, rather than litigating and going to court. For someone looking to explore the options outside of the court process, there are a lot of options available. So you can certainly negotiate between yourselves, and you can do that with or without the help of a lawyer. You can also attend mediation. Family law mediation can be a really great tool. You have a third party who is there to work with you and help you both come to an agreement. With mediation, the mediator doesn't actually decide what happens. Both parties still have to agree in order for there to be a settlement, so there is very little risk involved. At the same time, it is important to know that mediation may not always be appropriate for every couple, especially if there's a history of violence or maybe a significant power imbalance. Another good option in Manitoba is called Judicially Assisted Dispute Resolution, or JADR, and this is essentially mediation, but with a Manitoba Court of King's Bench Justice as the mediator. The benefit here is that the parties get some say in which judge will ultimately act as the mediator in their case, and having a judge as a mediator can really help move things towards settlement. The judge can really level with the parties and let them know where they see the strengths and weaknesses of their case, and particularly if you have one party who has maybe taken a little bit of an unreasonable position, this can be helpful. But again, the judge can't make any decisions for you, so at the end of the JADR, the parties do still have to agree in order for there to be settlement. Next up, we have arbitration. Arbitration is another process that can help couples or families resolve their legal disputes outside of the traditional court system. So the arbitrator, once again, acts as a neutral third party, but unlike with mediation, the arbitrator's role is actually going to be to make a decision or a determination about the major issues in the case, like child support, parenting, spousal support, and so on. Usually, both parties will sign an agreement ahead of time called an arbitration agreement, which says that anything the arbitrator decides is legally binding, meaning the parties have to follow it. And the parties or their lawyers will later draft a written agreement with those same terms. During the arbitration hearing, both parties can present their case by providing evidence, calling witnesses if necessary, and also making arguments to support their positions. So in a lot of ways, it is like the trial process. One of the advantages to arbitration is that it allows the parties to have a little bit more control over the process and perhaps the outcome compared to actually going to court. And it's often more flexible, efficient, and it can be a little bit less formal than the traditional court system. Additionally, arbitration proceedings are private and confidential. However, it's important to keep in mind that arbitration is still a voluntary process, so this means that both parties have to agree in order to participate. In Manitoba, we also have a service called the Family Resolution Service. It is a provincial program that offers various supports for people who are dealing with family law issues. They offer mediation services, safety planning, conflict resolution. They can walk people through the court process and help them complete their prerequisites, and much more. For more information on the Family Resolution Service and how you can access their services, check out the Government of Manitoba website. The next big question that people often ask is, do I need a lawyer? How do I know if I need a lawyer, or can I represent myself? Anyone can self-represent, but it is often a good idea to get advice from a lawyer. Even if you and your ex-partner get along and completely agree on all the issues, there might still be a very good reason to talk to a lawyer. For example, if there's going to be any sort of separation agreement in place, both parties will usually need to get independent legal advice at the very least. But really, a lawyer is there to let you know what your rights are, what your options are, and it's a way of protecting yourself. Some people do turn to the internet for family law information, but there can be quite a bit of misinformation out there, and family law can also be quite specific to the jurisdiction, so it's important to tread carefully. If you look at materials from elsewhere or even outdated materials from Manitoba, you might not be getting the full picture. This is one of the many reasons that it can be a good idea to talk to a lawyer before finalizing any sort of separation agreement. At the same time, getting independent legal advice can prevent you from entering into an unfair agreement under duress or coercion, or simply because you didn't know any better. And even just for the sake of drafting documents like a separation agreement, it's good to make sure that what you're agreeing to and what you're signing is actually going to be enforceable in your jurisdiction. You might find some separation agreement templates online, and maybe some of them are fine to use, but it's always better to talk to somebody who knows this area of the law and who can advise you properly based on your specific situation. Because the last thing that you want is to spend all of this time and potentially money drafting a separation agreement, and when the other person doesn't follow it, and then you end up having to go to court, you realize that the agreement that you made was not even enforceable. So, having a lawyer at the front end is really a way of protecting yourself and making sure that things like this don't happen. Lastly, lawyers can be very helpful in settling even quite contentious matters, even in situations where maybe it's a very high conflict separation. So, just because you retain a lawyer doesn't necessarily mean that you're going to have to go to court. Okay, next let's talk a little bit about the different options available to someone who is looking to maybe hire a lawyer or get some legal information or legal advice. So, first we have legal aid. Legal aid eligibility depends on your income and family size, so the cutoff changes every single year, and you can check what that cutoff is on the Legal Aid Manitoba website. If your income is within that eligibility range, then you may be entitled to a free lawyer. There's also a cutoff for people with slightly higher incomes, and this is for Legal Aid's Agreement to Pay program. So, on this program, you usually make monthly payments to Legal Aid, but it is at a greatly reduced amount. If you have assets that are worth enough that you might be able to pay for a lawyer if you were to sell them, then you may be refused legal aid. However, if those assets are locked in and you're not able to use them, or if using them would cause you a great deal of hardship, then Legal Aid Manitoba may still be able to grant you a legal aid certificate. If you own a home or another piece of real property, Legal Aid Manitoba may place a lien on that property, and they may also do a statutory holdback. So if you are awarded money in your case, they may hold some of that back to repay some of the cost of the legal services that you obtained. The other option is to hire a private bar lawyer. So some private bar lawyers do accept legal aid certificates, and this is on a case-by-case basis, so you'll have to check with that individual lawyer. However, of course, you can also retain a lawyer, meaning that you will pay for their services and their representation. Generally, the way that payment works when it comes to legal fees is that you will pay what's called a retainer, and you will also sign a retainer agreement with that lawyer. So the retainer acts sort of like a down payment on your legal matter. As the lawyer does work on your file, they will track their hours and the time that they've spent working on your matter, and they will then bill out according to their hourly rate. If your file wraps up and there's still money left in that retainer, then the lawyer will return that money to you. However, on the other hand, if your retainer runs out of money before your file is concluded, you'll probably have to top off that retainer in order for the lawyer to continue working for you. Of course, this depends on each individual firm or lawyer, so make sure that you speak to your lawyer to ensure that you understand the payment scheme that you are agreeing to. Some law firms, although very few in Manitoba, also offer something called unbundled services. And unbundled services refer to a more flexible approach where you can hire a lawyer to assist you with only specific tasks or parts of your legal matter. So you can choose which parts of the legal process you need help with and only pay for those services. For example, if you're handling a court case, you can hire a lawyer to draft your legal documents, provide you with legal information or advice along the way, and maybe they can represent you in court for a specific hearing while you still handle other aspects for yourself. It provides a lot more affordability and more control over the legal process, and you only pay for the help that you require rather than the full scope of representation. Lastly, I'm going to talk a little bit about CLIA's Law Phone-In and Lawyer Referral Program. The way that it works is we have some lawyers on staff. We have a phone number and an email address that we can be reached at, and anyone can reach out to us if they don't have a lawyer and they need some legal information. And if they later require a referral to a lawyer who practices in that area of the law, CLIA can do that as well. And the lawyer then has to provide a 30-minute free consultation through that referral program. Okay, next, let's talk a little bit about what you can expect when you meet with a lawyer for the first time. So, a lot of lawyers do offer a free initial consultation, but some charge an upfront fee for that consultation. It's always a good idea to come prepared in order to save time and therefore save yourself money. So, in a family law issue, it's a good idea to think about things a little bit ahead of time so you know what information is going to be relevant for your lawyer to be able to pick up the file. So, things like corollary relief, think about, what your expectations might be for things like custody, for child support, spousal support, property division, and so on. As well, what do you think your ex-partner's expectations are going to be? Do you think that your views with them on those things are going to be aligned, or do you think that there's going to be some disagreement? Other things to tell your lawyer. Other things to consider might be whether there's a protection order in place. Do you think you might need a protection order? Is there a history of things like family violence or intimate partner violence? Is there a history of mental health issues or addiction issues? Anything that you think might be relevant to your matter, bring it up with your lawyer, because the more that they know at the forefront, the better they will be able to assist you with your file. Even if it's something that you think might make you look bad, if you think it might come up during the course of your family proceedings, it's a good idea to tell your lawyer so that they can be prepared if and when it does come up. Lastly, it's going to be relevant whether the children have ever been apprehended by CFS, whether there is any previous or current CFS involvement. This is definitely something you will want your lawyer to know about. There are also a few things that you can bring along with you that your lawyer is probably going to request anyway, so this will save you the time of having to go back and forth. But that's going to be your last 3 tax returns, or preferably your notices of assessment. They will likely ask for your last 3 pay stubs as well. Also, things like lists of property, so your assets, any debts that you might have, the values of those things, and any supporting documents that are proof of those values. And lastly, if parenting arrangements are something that is going to be a live issue in your family law matter, there is a mandatory course that everyone has to take. It's available for free online, and it's called For the Sake of the Children. However, it's a good idea if you have children and you're going through a separation to do this course right at the beginning, because it does offer parents a lot of information and important tools as they work through a separation or divorce. Now, let's talk about what steps you can expect your lawyer to take. So, usually in a family law matter, the initial point of contact is a letter to either the other party directly or to the other party's lawyer if they already have one. And the letter is often an attempt to reach out and see if there's any chance of negotiation and settlement. Some people do choose to notify the other party ahead of time that they can expect to either hear from their lawyer or receive court documents. And of course, you should only do this if you think it's appropriate and safe to do so. But if it is, it can really help keep things amicable so that the other side doesn't feel blindsided hearing from a lawyer. Next, your lawyer is probably going to attempt to negotiate and settle matters with the other party. There is a mandatory 4-way meeting that has to happen before proceeding to court, and this is usually an attempt at settlement by bringing all of the parties together in a room to discuss the issues and really see if there is some opportunity for the minds to meet and for agreement to be reached. However, if things can't be settled or negotiation discussions are not progressing, then there may be a need to file court documents. Sometimes lawyers might skip straight to this step and just go ahead and file court documents right away, and they might do this maybe if there have been previous attempts to settle and they have been unsuccessful, or maybe it's just the best way to move matters forward in your particular situation. However, even in cases where those court documents are filed right away, there is still that mandatory process of negotiation and trying to settle the matter outside of court. Ultimately, it's important to remember that the lawyer takes direction and they take their instructions from you. Of course, you should be able to rely on your lawyer for their legal expertise, and they will be able to advise you on how best to handle your legal matter. But if at any point you're feeling like you don't understand things, or you're not sure why your matter is going in a certain direction, or maybe you just need some clarification, it's important to make that known to your lawyer and communicate that to them. Next, let's talk a little bit about the court process and procedure and what that's like. So in Manitoba, we have two different levels of court that deal with family matters. The first is the provincial court, and the second is the Court of King's Bench Family Division. So usually the provincial court will only deal with certain family matters in rural and remote areas. Generally in Winnipeg, you'll see that the Court of King's Bench Family Division is where those family matters are going to be filed. When you file those initial court documents, the type of document that you file is going to depend on whether you are going through a divorce or a common law separation. For a divorce, you're going to be filing your petition for divorce, your financial statement if there are any support or property issues that need to be dealt with, as well as your demand for financial information, which requests those same documents from the other side. And if you're going through a common law separation, you are going to be filing what's called a petition. And again, if you have those support or property division issues to be dealt with, you would file your financial statement and that demand for financial information as well. In Manitoba, we have something called the triage system, which was introduced in 2019. And essentially, this is a new system where parties are not able to proceed to court and actually be in front of a judge and have their matters heard until they complete certain prerequisites. And this is just to ensure that parties are doing everything possible to try to resolve and settle matters outside of court. Once your triage prerequisites are complete, then you will proceed to a case conference, and at that initial case conference, a trial will be set. Generally, trials are booked about 12 to 15 months after the first case conference, but this just depends on court availability. And between that first case conference and the trial, you will continue to meet with your case conference judge regularly. It will be their role to see if there is any opportunity to settle and resolve matters, and if not, then the matter will, of course, proceed to trial. So, what are the prerequisites that have to be completed before going to court? The prerequisites that you will have to complete are going to depend on the issues that still have to be decided. Everybody has to attend at a four-way meeting, no matter what. Sometimes these meetings happen over the phone or by Zoom, but they can also be in-person meetings. If there are support issues or property division issues that still have to be dealt with, you will have to make sure that all financial disclosure is complete. If there are issues about property division, then there's a family property accounting that has to be done, and you have to file a comparative family property statement along with that. Exams for discovery also have to be completed, or you have to have undertaken to complete them. Exams for discovery are an opportunity for each side to ask the other party questions, which can then be used at trial. And this process is also sometimes known as deposition in the United States. If you have parenting issues that still have to be resolved, then each party will have to file a parenting plan. You will also have to decide whether or not you want to conduct an assessment, and you will both have to complete the For the Sake of the Children program. And again, there may be other prerequisites that you have to complete depending on what those issues in your matter are. Now, what can you expect when you go to trial? Ahead of the trial dates, both parties will have to file their certificate of readiness that says that they have complied with certain requirements in order to be able to proceed to trial. Trials will not be canceled unless settlement documents are filed and signed. As far as the trial itself, it's essentially what you would picture, where both parties get to testify before the judge, they can call witnesses to prove their case, and they can also introduce documentation and evidence to prove their case. Now, as I've said, you generally can't proceed to court and actually have your matter heard in front of a judge until you've completed those prerequisites. However, there are certain circumstances where you can go to court before completing those prerequisites. So the first is with a hearing before an associate judge. In Manitoba, associate judges have the jurisdiction to be able to grant a variety of orders, and there are certain types of orders that you can actually ask for before going to triage. Some of the orders that associate judges can grant include orders for substitutional service. So, if you want to serve someone with court documents but you're not able to find them, or if someone fails to comply with prerequisites, or maybe they're failing to provide financial disclosure, associate judges can also grant an order forcing them to do these things and awarding costs if they fail to do so. We also have emergent hearings, so you can appear in front of a judge before a triage conference on short notice if you think that there is a chance of immediate risk to a party or a child, removal of a child from Manitoba, or a loss or destruction of property. The way that it works is you have to file a request for an emergent hearing. You file this along with your affidavit, which explains to the judge why you think an emergent hearing is necessary, and the judge will then review those documents and they will decide whether or not they want to hear the emergent hearing. If they decide to do so, then the hearing usually takes place within a couple of days, and the judge can actually make an order at that hearing. However, once that order is made, you still have to comply with prerequisites in order to proceed to triage and finalize all other issues in your case. And that brings me to our last slide here. So here we have the Winnipeg number as well as the toll-free number for the Community Legal Education Association Law Phone-In and Lawyer Referral Program. I'm also leaving our email address on the screen as well as our website, which has a lot of great resources, information, publications, and videos. And lastly, we have these two government websites. We have the Family Law website, which includes information about the Family Resolution Service, and the Manitoba Courts website, which provides information about forms, procedure, and other court information. Thank you so much for joining us. If you do have any questions, please feel free to reach out, and we will see you in part 2.